Domicile in jobs. The Haryana State Employment of Local Candidates Act 2020 mandates that 75% of jobs which offer a salary of less than rupees 30,000 gross a month have to be reserved for candidates hailing from the state. The law was made applicable to all types of employers in the state, so it includes private enterprises, societies, and trusts with more than 10 employees. The law, which came into effect on January 15, 2022, has a sunset clause. It will be applicable for 10 years. It is not retrospective in effect and would apply in new recruitments. An employer faces a fine up to rupees 2 lakh for not complying with the law. Several industrial bodies and individuals filed pleas against the law in the Punjab and Haryana High Court. On February 3, 2022, the High Court granted an interim stay on the law. The Haryana government went to the Supreme Court on the issue. The Apex Court set aside the High Court stay order on February 17, saying that a law passed by a legislature is presumed to be legal and there should be reasons for staying it. But the Haryana and Punjab High Court had not given sufficient reasons for its stay order. A law cannot, after all, be stayed unless it is found to be unconstitutional or grossly illegal. The Apex Court did not, however, go into the merits of the case but sent the case back to the High Court, asking it to decide the case expeditiously within 4 weeks from the date. It also ordered the state government not to take coercive steps against employers for the time being for not following the law in question. Relevant constitutional provisions. As per Article 19(1)(d) of the Constitution, all the citizens of India shall have the right to move freely throughout the territory of India. Article 19(1)(e) states that all citizens of India shall have the right to reside or settle in any part of the territory of India. Article 19(1)(g) gives the citizen the right to practice any profession or to carry on any occupation, trade, or business. The restrictions on the first two provisions are in the interest of general public or for the protection of interests of any scheduled tribe. In the case of Article 19(1)(g), a state is not prevented from making a law relating to number 1. The professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. Or number 2, the carrying on by the state or by a corporation owned or controlled by the state or any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizens or otherwise. Article 16(1) of the Constitution gives every citizen the equality of opportunity in matters relating to public employment. Article 16(2) of the Constitution states that no citizen shall, on grounds of descent, place of birth, residence, be ineligible for or discriminated against in respect of any employment or office under the state. Article 16(3) of the Constitution allows only Parliament to make a law prescribing a requirement of residence for jobs in a particular state, and Parliament, exercising its powers under Article 16(3), enacted the Public Employment Requirement as to Residence Act, aimed at abolishing all existing residence requirements in the states and enacting exceptions only in the case of the special instances of Andhra Pradesh, Manipur, Tripura, and Himachal Pradesh. Court decisions. In various judgments, the Supreme Court has said that domicile based job reservations can only be made after a detailed study providing evidence of socio-economic and educational backwardness and the reasonable ground for reserving jobs for locals has to be quantifiable. This study has to be done in a proper scientific way. In the ruling in Dr. Pradeep Jain versus Union of India 1984, the Supreme Court stated that policies like Sons of the Soil would be unconstitutional. In 1995, in the Sunanda Reddy versus State of Andhra Pradesh case, the Supreme Court struck down a state government policy that gave extra weightage to candidates who had Telugu as their medium of instruction in their education. In 2002, the Apex Court held invalid the Rajasthan government's action of appointing government teachers in the state, giving preferences to applicants belonging to the district or the rural areas of the district concerned, even though the appointment was in state supported institutions. The court considered the action would be rejected on the plain terms of Article 16.2 and in the light of Article 16.3. The court said that the action runs counter to our constitutional ethos founded on unity and integrity of the nation. In 2019, the Allahabad High Court struck down a recruitment notification by the Uttar Pradesh Subordinate Service Selection Commission in which a preference for women who are original residents of the state was prescribed. Critical analysis. It is clear from the provisions in the Constitution that the government is allowed to prescribe residential criteria for jobs. It is in the public sector that it is allowed to do so. Moreover, it is Parliament that can make such a law. The question arises how a state assembly can legislate on domicile for jobs in the private sector. However, some states in India have passed resolutions and laws to have domicile based reservations of jobs in the private sector industries. The Andhra Pradesh Employment of Local Candidates in the Industries Factories Bill 2019 was passed to allow the state government to mandate that existing and upcoming industries in the state should reserve 75% jobs for locals. Following Haryana's move, the Jharkhand Legislative Assembly passed a bill providing 75% reservation for locals in the private sector for salaries up to Rs 40,000 a month. Maharashtra, Madhya Pradesh and Tamil Nadu have made promises on reservation of jobs for locals in the private sector, but they have not yet been translated into laws. In support of such reservations, those who justify the domicile based job quota in the private sector point out that it is one way of providing employment to local unemployed youth, especially from the backward classes. The government alone cannot provide employment to all. The private sector has to be roped in to do its bit. After all, it is pointed out many private sector industries get government aid and tax benefits. Most private sector companies have negligible number of employees from the scheduled castes and scheduled tribes, mainly because of concerns over their lack of skill and language disabilities. Through reservation, these classes would be able to get representation and a chance to improve their skills. Moreover, they would get appropriate training on the job. The employment scenario will become more inclusive. In any case, the job quota is applicable only in those jobs with a limited salary. Counter views. There is much opposition to the idea of reserving jobs for the locals in the private sector. Domicile based job reservation runs counter to the concept of One India. It amounts to divide the spirit of unity in the Indian Federation. It goes against constitution given rights and provisions. When India became a republic and the constitution came into force, the country also became a single geographical unit of individual units. The country has single citizenship with citizens enjoying the freedom to move around freely in any part of the country. The constitution allows parliament to legislate on residence as a condition to some jobs, that too in a public sector. So how can such reservations be extended to the private sector by state legislation? In wake of rapid urbanization and the pressure on the agricultural sector, there is widespread internal migration. Workers go to places where jobs are available to meet their skill and expertise. Labor from outside is needed for any industry because locals are either unavailable or unwilling to do some jobs. Shackling the individual rights of workers amounts to poor economics, besides creating conditions for social and economic instability. Not allowing persons to take jobs in another state would, in the end, amount to restricting their choice of residence as well. Talent and abilities are basic to the success of the private sector in a competitive world. Reservation of any kind is bound to compromise this factor. Domicile quotas can raise costs and inefficiencies in states to which labor tends to migrate. At the same time, it will exert short term pressure on labor supplying states to create productive capabilities. Such reservations can distort the labor market, particularly when local political groups act merely for their electoral gains. Concern has been expressed about whether enough local skill would be available to fill the quota. There is a provision that the organizations may be exempted if local candidates of the desired skill level are not available for a particular set of jobs. But the government need not accept the organization's claim to this effect. It may direct the organization to train the locals. In the long run, domicile based reservation would also tend to be self defeating, driving away investment and depriving local economy of needed skills and productivity. So, such a policy is neither in the interest of the nation nor can it do any good to the states concerned. Conclusion: domicile based jobs are on the whole not a good idea, though in the case of Haryana the law is for a 10-year period. Will it really come to an end after that period? Even small industries will be adversely affected. In the end, the economy will suffer. To meet the challenge of unemployment, states should adopt an employment centered model of growth. It should have an education and skilling ecosystem to produce job ready workers. More effort should be made by governments to reduce disparities between urban and rural areas and between advanced and backward states and regions. The policy of a domicile based job reservations is a means to divert attention from the failure to do this. The courts have still to decide on the constitutionality of such laws. Many more topics like this one in the book Topical Issues in Indian Polity and Indian Economy, precise, analytical, comprehensive.